Hello everyone. Myself Pranav Gurav. I'm an assistant professor of law, and in today's video, we are going to discuss about the concept of crime. The concept of crime. So, when we hear the word crime, we get general idea about it, right? What is to be considered as crime? What can be considered as a crime? So we perceive it. We have certain knowledge about it. But if we try to strictly define the term crime, it is very impossible. It is very impossible, I'm saying. Because crime is a very vague concept. It's not a static concept. It cannot be rigidly defined. It cannot be put into a bracket. So it is very impossible to define crime. Why am I saying that? Because it is a social phenomenon. Crime is a social phenomenon. It changes from society to society. It evolves as a society evolves. It changes from place to place. So what is considered as a crime in India may not be considered as a crime in United States or UK or any other country. Right? It's not necessary that the act of crime in India must be act of crime throughout the universe. So the concept of crime changes from place to place. It changes from time to time. So what was a particular act was considered as a crime in ancient India, it is not necessary that the same act is considered as a crime in today's times. Right? So it changes from time to time also. And it depends on multiple facets of a particular state. It depends on what kind of right has been infringed. Right? So accordingly, the concept of crime changes. It does not remain static. That is why it is very impossible. I'm using this particular word very specifically because we cannot concretely define crime. Many of the jurists have tried to define crime, but all those definitions have certain lacunas within themselves, because all the characteristics, all the ingredients of crime cannot be fitted into one single definition of crime. That is why it is very difficult, right? So what is crime? We have to understand, we have to put certain draw certain characteristics, draw certain ingredients to understand what is crime. Necessarily or generally, a crime is a wrongful act in a particular society which is prohibited by law and which is punished by law. Right? We have to go to the basic human instincts to understand what is crime. See, human is a social animal. We say a lot that human is a social animal. What do we mean by that? That the human cannot live in isolation. He has to live in the society. He has to deal with other people. He has to communicate with other people. Right? Then and then only he can live a human life. Human mind is made in such kind of manner. Right? That is why he needs to live in the society. And when he is living in the society, he is dealing with other people. He is talking with other people. He is communicating with other people. And when he is communicating with other people, he has to follow a certain pattern. Right? As in isolation, there are no restrictions upon his behavior. But when he is living in a society, there are certain restrictions. There should be certain restrictions upon his freedoms, so that every single person in the society lives his life in a peaceful manner. So human behavior must be regulated in a particular society. Then and then only civilized and peaceful life is possible. That is why, and that is how, the concept of rights, obligations and liabilities have came into existence. The state has come into existence and the instrumentalities of state have come into existence. So what could be considered as a wrongful act? When we are enjoying our freedoms in the society, at the same time, if we are enjoying those freedoms in such a manner which would be infringing rights of other persons, we are causing injuries which are causing damage to other persons or the properties of other persons, then we are doing certain wrongful act which is prohibited in that particular society, right? So we get an idea of a wrongful act which is prohibited by the society, by the instrumentality of law in a particular state. Because the society does not create law, state creates law, and state is the representation of the society, right? So that wrongful act is that act which is prohibited by the law, and that law is created by the state. Okay, and within that wrongful act, that kind of wrongful act which is not repairable, or the consequences of which are not repairable in nature, any kind of damages cannot be provided to restore the right of another person. They would not be sufficient, they would not be enough to restore the right of other person, and which causes an impact upon the society at large, which causes an impact upon the state at large. That wrongful act can be considered as a crime, right? So a person is doing a wrongful act which is causing injury to rights of other persons, and that injury is of such a nature which causes such kind of consequences which cannot restore the rights of other persons, and which causes alarming impact upon the society as such. It is to be considered as a crime. Okay, so with this background, we are going to see certain definitions provided by certain criminologists of the concept of crime. The first definition that is provided here is of a renowned criminologist, Tappan. He has stated that crime is an intentional act or omission in violation of criminal law, committed without any defense or justification, and penalized by the law. So we have to break down this definition to understand the characteristics or the ingredients of crime. First of all, he is saying that crime is an intentional act. The first important word in this definition is intention. So without intention, without prerequisite element of functioning of human mind for doing that act, without formation of intention, a crime cannot take place. So to attach a criminal liability, there must be intention. Without intention, a person cannot commit a crime. So that is why accident cannot be considered as a crime. Because when the accident takes place, there is no intention to do that act. It happens accidentally, right? So that is why crime requires a functioning of human mind for doing that act. It requires the willingness on part of the wrongdoer to do that act, or it requires knowledge on part of the wrongdoer that because of this act certain prohibited consequences will be there. So that kind of intention or knowledge must be present with the wrongdoer, and with that intention he must do that act. So there must be an intention. Then second characteristics is that act or omission. No, only intention is not sufficient. It is not enough. Because if I have an intention to commit a robbery at the place of A, I am having that intention. I have prepared a plan to commit that robbery, but I do not act upon it. Mere having intention to commit the robbery is itself not sufficient to constitute that particular act as a crime. Certain physical overt act is necessary in furtherance of that intention to consider that act as a crime, right? So to fulfill that intention, certain overt act is necessary. Certain commission is to be there. Act committed must be there. Then and then only it can be considered as a crime, right? So he has bifurcated between act or omission. Act means commission of act. Certain positive act is necessary. Theft is committed, murder is committed, dacoity is committed. right? So he is doing something positively, affirmatively. He is taking certain actions to do those things which are illegal, and those things are done by him intentionally, right? That is commission of an act. What is omission? Not doing that thing which he is required to do. So a person is duty bound to do something, he is obligated to do something, and he does not fulfill his obligations, he does not perform his duty, thereby he causes the omission, and that omission is intentional omission. That would be also called as a crime. So a crime covers affirmative action of committing crime as well as negative action of not doing something which would give liability of crime, right? So it may be act or omission. Intentional act is there, intentional omission is there, and it is necessary to be in violation of criminal law. So state must have prescribed criminal law of that particular land, right? So there must be a specific law which provides what is crime, what are various crimes, what are various offenses, which lays down the list of offenses and which provides punishment for those offenses. So if there is no criminal law of the land, there cannot be considered as a crime according to his definition, right? So for this definition to be fulfilled, we need state, we need law, we need criminal law, and that criminal law must contain list of crimes, list of offenses, list of those things which are prohibited by that law and for which punishment has been provided. Further, it has been stated in the definition itself. Violation of criminal law, and that act must be committed or omitted without any defense or justification. So there is no defense, there is no justification for doing that act. Then it would be considered as a crime and it is penalized by law, right? So there must be criminal law, and that criminal law must provide punishment for that particular act. Then and then only it could be considered as a criminal act, it could be considered as a crime. I have stuck in the word without any defense or justification. The intentional act or omission committed against the criminal law, and it is penalized by the criminal law, and that act is not covered by any defenses or by any justification. We can apply this particular definition in today's times also. If we look at the nature of IPC, if we look at the new law, Bharatiya Nyaya Sanhita, there are justifications provided, right? There are excuses provided, under which if a person does an act, that act would be considered within the meaning of justification, then he would not attract the criminal liability, right? For example, private defense, right of private defense. If a person kills another person for defending himself, right? If A and B are there, first B attacks A, and while defending himself, A fights back against B, and in that particular fight, B dies. Then A is justified to cause death of B, right? A is justified to cause death of B. Otherwise, A will not be justified. Just because B has attacked A and A is acting in self-defense, A's actions are justified actions, excused actions, right? If B had not attacked A and A had first of all attacked B, then it would be considered as murder. It would not be excused by the law, right? So if you are doing an act which would be generally considered as a criminal act, but you are doing out of certain necessity which is covered under defenses or justifications, then you would not attract the criminal liability. So these are the ingredients of crime which we can derive, we can ascertain from the definition of tappan. Now next definition is of Kenny. He has stated that crimes are wrongs whose sanction is punitive and is in no way remissible by any private person but remissible by the crown alone, if remissible at all. So first of all, he states that crimes are wrongs. It is not a rightful act. It is a wrongful act. It has been declared by the state that it is a wrongful act. And whose sanction is punitive. It is not just a wrong. It is not just a civil wrong. It is that kind of wrong for which punishment has been provided by the law of that particular land. Then it would be considered as a crime. Right. So wrongful act for which punishment is provided, and that punishment cannot be pardoned by any private individual. If we look at the nature of crime, we can understand it. If A commits robbery at the place of B and B files a complaint against A, then afterwards B cannot withdraw that complaint, because that act, even though that act of robbery is against B, it is causing an alarming impact upon the society at large. It is causing an harmful impact upon the society at large. And that is why crime is that phenomenon which could be considered against the society at large, even though it is committed against any private individual. And that is why, even though the person against whom the crime has been committed is suffered by that crime, he cannot pardon the offender. That is the reasoning behind it, for not granting the power to that particular private individual of pardoning the offender, pardoning the criminal. Because crime is considered as a harmful act upon the society at large. And that is why crime is prosecuted by the state. In the criminal prosecution, in a criminal case, there is no accused versus primary victim. There is always state versus the accused person. State initiates the prosecution. State tries to prove, prosecution tries to prove the guilt of the offender, because the crime is considered as a crime against the society at large. And that is why it is not pardonable, it is not remissible by any private individual, even though that private individual is a victim himself. Right. And what has been further stated in this definition, it is no way remissible by any private person but remissible by the crown alone. So only crown, only head of the state is empowered to pardon, to grant the pardon to the criminal. This definition is applicable in today's modern times also. How come so? Under Indian Constitution, President of India as well as governors of various states enjoy the power of granting pardons in certain specific offences to the offender. For example, in case of murder, if a Supreme Court has awarded death penalty upon that particular offender, that offender can file a mercy petition before President, and President has the discretion to award pardon in that particular case to that particular offender. So, crown has been replaced by the President. In those times when this definition has been given by Kenny, in those times, crown was the head of the state. In today's democratic society, in today's democratic states, President is head of the state. And that is why the power which was enjoyed by the crown is enjoyed by the President in today's modern times. And he is empowered to grant pardon. So only head of the state is responsible, rather empowered to grant pardon if there is a violation which is to be considered as a crime. Okay. So he is talking about the aspect of remissibility, and he is talking about the aspect of crime against the society at large. The crime is to be considered as act against the society at large. Okay. So this is the definition provided by Kenny. Now the next definition, which is very interesting definition given by a very famous jurist, John Gillen. He states that crime is an act that has been shown to be actually harmful to the society, or that is believed to be socially harmful by a group of people that has power to enforce its belief and places such act upon the ban of positive penalties. The first significant word terminology used in this definition is that an act that has been shown to be actually harmful to the society. He rather would have said an act that has been actually harmful to the society, but he uses the specific word purposefully, shown to be. So that is why crime cannot be considered as a rigid, a static concept. If a persons who are in power, a group of people who are running the government, who are running the state, are following certain type of political ideology, they may forbid certain activities in that particular state. They may ban such activities in that particular state which are against their belief system, which may not be against the society at large, but they are against the ideology of those persons who are in power. And that is why shown to be word has been used, or believed to be word has been used. So if a persons in power are believing that certain acts are against their ideologies, they can declare such acts as crimes. So the persons, if they are showing certain acts as crimes to the society, or they are making the people in the society believe that such acts are crimes, then those acts are to be considered as crimes, right? So that is why who are running the state becomes very important to understand what act constitutes as a crime and what act does not constitute as a crime. It depends upon the political ideology. The people who are in power will ban such kind of activities which are against their ideologies, right? That is why in a democratic country, mere criticism of government would not amount to crime, but whereas in a totalitarian country or in dictatorship, mere slightest criticism of government would amount to crime against the state, and it would be dealt with harshest punishment by that particular person in power, by that authority in power, right? So it depends upon the those persons and the belief system of those persons who are running the particular state, what is to be considered as crime. Okay, so these are certain definition which gives idea regarding crime, from which we can derive certain characteristics of crime, but we cannot articulately define the concept of crime as such. Okay, thank you.